Hello, my name is Robert K. Collier, and this is the campus of the community college where I graduated in 1994. I received an associate's degree in liberal arts. This is a video message for those listed on the Social Security Instructions to Service a Civil Action Complaint, which are Social Security's General Counsel and the United States Attorney's Office. Other recipients include parties that may have an interest, such as attorneys, authorities, judges and justices, doctors, and creditors. This video message is a follow-up to correspondences by mail, including verbal messages and personal communication. I will now go into the school's law library and deliver the message. Thank you. Hello. Again, my name is Robert K. Collier, and this is a video message for Social Security's General Counsel and the United States Attorney's Office. The location is Northwest Mississippi Community College, where I graduated in 1994. The first of this video is a sign of their video shot of their new sign, and I graduated in 1994, and that's when I decided to go use to see if I could retrieve my Social Security disability benefits, in which that is what this video message is about. The reasons and facts I need to make sure that the appropriate people are getting the information because it's very important to me. And this situation is approaching a very long time period, and I need to make sure that you understand where I'm coming from. So I have some reasons and facts that I need to give to you and supply. And I need to let you know this video will be about 35 or 40 minutes long, and I'll try to make it as short as possible, and I will be repeating myself, and you'll just please forgive me, and please bear with me. However, this message is very important to me. The reason I'm sending a video message is because I'm very uncomfortable verbally addressing the situation because of the amount of time, cost, and sensitive issues involved. I have Erb's palsy, and my palsy condition is bothered because of the situation at hand and the issues involved. However, I must continue due to the following reasons. Erb's palsy is a physical impairment. It is a physical upper extremity impairment, and it comes from the shoulder. If you look it up on the internet or push it in a search engine, you'll find lots of information about an Erb's palsy, a brachial plexus condition. I am a paralegal. I am a very good paralegal, and I graduated from the University of Memphis in December 2008 with a bachelor's degree of paralegal studies. This is my diploma from the University of Memphis. As I stated, I have Erb's palsy. It's a permanent physical disability from birth, and my disability is listed in the Code of Federal Regulations, the CFRs, which provide the qualifications to receive my Social Security disability, which I was planning to use for education. And it was after my graduation from here, Northwest Community College, where I received the associate degree of liberal arts in 1994. The Social Security money for education that I wanted to use is known as a PASS, or a Plan to Achieve Self-Support. Again, it's listed in the Code of Federal Regulations, and this is a copy of the 2003 CFRs, and the CFRs did change in '05, but basically when my judicial review, court review started, money for education is quoted as for the stipend or the pass or the plan. It's a full SSI payment. I decided to apply for the benefits, again, after my graduation from Northwest, and the process to activate my Social Security disability benefits resulted in a judicial review in both federal and state courts. The judicial review was lengthy but favorable to me in the Federal Court of Appeals and the Mississippi Supreme Court. I returned to school after the judicial court review and double-checked my work, wrote a variety of papers on the subject, and did my senior project on the court review, titled Social Security's Plan to Achieve Self-Support. This is a copy of the final academic research paper, and the United States Attorney's Office, along with Social Security's General Counsel Office, should have a copy. I hand-delivered a copy to the United States Attorney's Office and certified mail Social Security's General Counsel in Baltimore and Atlanta a copy of the academic research paper. I accrued a lot of educated-related expenses, about $250,000, which have become past due, and I have creditors that need this message also. And the amount of the $250,000 just included basic necessities and essentials, divided over a time period from 1994 till I graduated in December '08. I would like to continue my education with a master's degree and or law school. However, I must have the issues in the judicial reviews settled before I continue with my education, because of money for education was the initiative for the judicial review, and education expenses and compensation are attached in the judicial rulings, judgment, and order. The judicial review and continuing education produced, again, a cost of about basic necessities of $250,000, along with an array of avenue options, resulted in a very lengthy process. I need assistance in finalizing and reaching a peaceful settlement of the judicial review. Again, I have creditors who need this information, and they are phoning on a regular basis to collect their balance, because I am no longer able to pay for the cost and expenses which were explicitly covered according to the waiver, the federal court, the money judgment, the motion, the ruling from the Federal Court of Appeals, and the order and the judicial court review. I need a monetary payment, please, immediately, because I owe it to creditors. And again, I'm not able to pick up the expenses which have become past due and are covered in the court, what the courts have awarded, but I haven't received. I think it's unfair to ask me to cover the expenses accrued because of the mistakes of others in the disbursement of my Social Security disability check, including a shortage of funds. My monthly Social Security payment is basically half of what the tender level should be, and I'm referring to the PASS, or the Plan to Achieve Self-Support, which I have never received because of the judicial review procedure. As the Federal Court of Appeals and the Mississippi Supreme Court has recognized. Both money damages were recognized by both appeals court through the Tucker Act, and on the motion the Fifth Circuit Court of Appeals granted in their ruling, which on the ruling it cites Howard versus King, and that grants the motion in forma pauperis form. I need the compensation that was awarded to cover the expenses that has accrued and to repair my shoulder and the physical damage, along with my elbow, that has occurred to my Erb's palsy. I need corrective surgery, again, on the palsy, due to the strain on the disability in this Social Security judicial court review. I'm very, the documented material I have sent to General Counsel, Social Security, and the United States Attorney's Office. I'll review it briefly, but everything is in the senior project. Here's another copy here. The senior project provides good information, and the court documents, which I will cover briefly, are in the senior project, in which both the United States Attorney's Office and Social Security's General Counsel should have a copy. Social Security remanded the claim to federal court. It is in the first index in the senior project from the University of Memphis. It was remanded to federal court from Falls Church, Virginia, stating instructions for a civil action complaint. State court was chosen because the original complaint was in the form of a federal question, and state court was chosen because the United States Attorney, whose answer is in the Appendix F of the senior project, the Assistant United States Attorney stated 3 times in her answer that the federal court had no subject matter jurisdiction. I didn't really know what to do. Of course, federal court has subject matter jurisdiction over this issue, but her answer was very bad to me. And when I tried to follow up verbally on the telephone, she wasn't available for comment, and there was no basically assistance from her. A federal judge, District Judge Biggers, entered a final judgment and dismissed the grievances and basically rewrote my complaint. After the final judgment, the complaint was no longer mine. It was a new complaint where the grievances were taken off, and I wasn't, therefore my complaint had been dismissed, and I chose to go to state court because that is the procedure when a final judgment is issued. It is in Title 42, I think it's Section 1986, Note 4441. It's also in the United States Code, and it is the procedure to go to a different court and then to go back and do a claim for payment. I did a claim for payment after the default judgment was entered, and I received a phone call in 1999 from Ms. Teresa Hoyt. She was with Social Security's General Counsel, and I laughed when she told me who she was. The situation I did not know was going to get to where it is today, 10 years later, or 12 years later. When I laughed, she became very frustrated and hung the phone up on me. I took it as an idea that she wanted to speak or talk to me, because she did tell me her name and who she was with, and I did get that much information from the conversation in '99. I went to Atlanta, and I stopped by the federal. There's a new federal building in Atlanta, the Atlanta Federal Center, and I told the people in the lobby that she had phoned me, and I thought she wanted to talk, and they sent me on up to the floor where General Counsel is. I wasn't prepared to talk. It was, I think, August the 4th, 1999, and I went up to speak with her, and they sent me around to her office, and I knocked, and she was standing there, and she was very agitated and very frustrated, and I apologized to her. I remember I introduced myself and told her that she had phoned me, and she took me down the hall into a conference room And I told her on the way there I did not know if I was willing to talk, but I could come back. But we talked for about 15 or 20 minutes, or maybe even less than that, 5 or 10 minutes. And along with Miss Sloan, and there was another gentleman there. I can't quite remember his name, I'm not quite for sure. And I told you what the problem was, that they had entered default in the amount of the default judgment, and the statutes were all off. And basically, Miss Sloan cut the conversation short. I think she was Miss Sloan, and said they would not be able to do anything at that point. And I said, well, okay, I'll have to go down to the federal courthouse and do a claim for payment. And I did. I did a claim for payment in Washington, D.C. in June, and of the following year, or the following year, and it was transferred, the claim for payment was transferred back to the Northern District of Mississippi via Judge District Kennedy. He gave an order overruling the United States Attorney's motion to dismiss the complaint. And the reason I filed it in Washington, D.C. was because I didn't think that Miss Jackson wanted me to come to the district over at 911 in Oxford because of the answer she gave and because of the final judgment given. But I did. District Judge Davidson did a striking of pleading and said not to file anything unless I wanted to go to Federal Court of Appeals, in which I did because I had their instructions. I had Social Security's instructions for a civil action complaint. There were serious errors of law on my Social Security account, and the administrative law judge's decision and the documents from the Grenada, Mississippi office contained a serious breach, and I knew there was a bad shortage of funds, along with a very severe misclassification, and I had to have that corrected. I'll elaborate on it in a few more minutes, but the Fifth Circuit Court of Appeals gave a favorable ruling. I call it a ruling. They ruled upon a motion. It has Judges Barksdale, Stewart, and Higginbotham on the ruling, and it is in the Washington, D.C. transfer order is in Appendix L, and the striking of pleading order is in Appendix M, and the notice of appeal to Federal Court of Appeals, which was for the order, to appeal the order, is Appendix N, and the ruling from the Fifth Circuit Court of Appeals is Appendix O. They cited their signals in citation are C, Yohe versus Collins, citation, and I have thoroughly briefed that case, and it declares there was no cumulative error in entering the state trial court judgment, and the defendants could not have relief of the state trial court judgment, and Social Security were the defendants. It's a lifetime conviction for the defendants, and again the signal is C, and in the paralegal review manual we cover signals and logically citations, and the signal C relates to a case directly that has direct relation to the other case, and therefore the state trial court judgment is affirmed. The Federal Appeals Court granted a motion on how the judgment and granted judgment. It was Howard versus King. The reason I say granted judgment is because on the motion I point out the serious error of law and address if I'm able to receive my Social Security based on a pamphlet, leaflet, or brochure. And the citation dismisses the district court's dismissal and grants the motion in former pauper's form, and I know that's mine because I know that motion is mine, and on the motion I tell the Tucker Act is cited, and I ask for money damages. Therefore, the Federal Appeals Court recognizes the Tucker Act and the money judgment, the state trial court judgment, and I was very happy with it, and I was very excited, and the motion is in the senior project, and it is Appendix R. Afterwards, Mississippi Supreme Court gave an order, and the order signal is quoting. We have two signals, C and quoting. But the Mississippi Supreme Court gave the order which approved the judgment and gave judgment entitlement to the judgment creditor, and the Mississippi Supreme Court cited United States versus Testan citation, which declares the case is for reclassification and back pay. And they talk about the Back Pay Act, the Classification Act. Sherwood's mentioned in the opinion, and the opinions are all the opinions are pulled and cited in the senior project. And then the next case is quoting Sherwood, which declares a breach of contract, and it approves and authorizes judgment creditor for money damages under the Tucker Act. Again, the Tucker Act is cited, and that's the second time it's cited, and it's cited by the Mississippi Supreme Court after the Federal Appeals Court approved the motion, granted the motion, which cites the Tucker Act. And then there's another case, and it declares no jury trial is available when the United States waives immunity, and it was basically discrimination. I cannot pronounce the name of the case. It's Lehman versus Nakshian or something like that. I'm not quite for sure. Please forgive me. And then I filed the order in compliance with the rules of federal procedure under discovery, which is in the discovery is in Appendix V, and the Federal Court of Appeals and the Mississippi Supreme Court allowed state court action and the default judgment. And the default judgment is entered on a mandate after the order, and the order clearly dismisses me, but it remands it to the consent of that to be sued, which declares that state court has they cannot hear the case, in which I understand that completely, but it remands it save. The jurisdiction is save of that consent to be sued, and I have the consent to be sued, and so it's a remand back to federal court, and that makes about 4 times they have sent me to federal court. Once from Falls Church, Virginia, again from Washington, D.C., again from the Federal Court of Appeals, and now the Mississippi Supreme Court. They sent me to federal court 4 times, and the issue is still, it may be over, in which Mr. Jim Greenlee, whose name appears on the brief, states. He's told me a lot of information. I've been staying in contact with him since the order from the Mississippi Supreme Court was filed under discovery, and he provided some information to me over a 6-year period. I have continually provided follow-ups to the Social Security Administration and their representative. When I gave the order from the Mississippi Supreme Court to the United States Attorney's Office, I had returned to the community college where I am now, where I graduated, to consider the paralegal degree, because administrative agencies allow paralegal work, and I wanted to incorporate the work. I was losing, and I still am losing, a lot of time, and it's costing me a lot of money, and so I was trying to put a degree together with the work and combine everything, and I'm very happy with that. And it's not necessarily that I want to be a paralegal, but it was just the wise choice. Jim Greenlee, whose name again appears on the defendant's brief cover in federal appeals court, personally told me if I could provide him and the Social Security Administration with the final cost, that we could work out something, among other things. I told him that I could, but I would have to borrow money to cover the expenses that had accrued and to further my education. I was not in a position to argue with him, because he became very agitated and irritated when I would bring the subject up, and he did not really want to discuss it. He would just tell me what to do and cut the conversation off immediately. and I wasn't, again, I'm very uncomfortable discussing the situation, especially at this point. I also told him that I was considering pursuing the Bachelor's of Paralegal Studies, and I could bring him a final product, which would be my diploma and the senior project, along with the final cost. When I did as he asked, he continually evaded. When I did ask, he continually evaded the situation with more hype, and I did not feel comfortable discussing the matter with him further because he was very agitated and irate. Mr. Greenlee also provided other information to me over a 6-year time period while he was the United States Attorney, which he resigned at the end of the beginning of '09. He told me 3 things that he told me: that he really could not represent SSA as listed on the instructions to service the complaint because of the error of law. He did not like the situation and referred to it as over. And recently, before he resigned, he told me I was still having major issues with the Justice Department, and he could not elaborate on them, which made me feel very uncomfortable. I have been asking for the money allowed by the courts actually since 1999, when the money judgment was entered on the State Circuit Court docket. I intensified my request for the monetary funds after the ruling from the Federal Appeals Court and after the order from the Mississippi Supreme Court. I again intensified my request for the money via a settlement agreement since July 2009, when I began receiving phone calls asking for payment on loans that I had to borrow to cover my expenses. I have certified mail receipts from the request. There are miscellaneous points of interest I need to make. Again, I've mentioned I changed my undergraduate to accommodate the situation, and I'm not really interested in being a paralegal, but the change was wise because of the situation. And another reason the change was a good idea is because legal representation was and is hard to locate, because I could not find an attorney who wanted to carry the Social Security claim through federal court, through a federal court review. They just didn't want to do it. They didn't want to have anything to do with it, and we do not do that. Sorry, I cannot help you. I would get messages like, you started it, you finish it, you know more about it than I do. It's your little red wagon, it's yours now, and you can have it. You need to finish it yourself. So I thought the paralegal degree would smooth a road out for open discussion. Anyway, in my paralegal studies, we covered that administrative agencies allow paralegals to do administrative work. And another reason I had to do this myself was I had to see the important court decision making and check the accuracy myself, because it is very serious to me to know what and why is in my Social Security account. The situation is serious. The names on the defendant's brief in the Fifth Circuit Court of Federal Appeals, here's a copy of the brief cover. They include Mr. Jim Greenlee, William C. Martin, I think they were in Oxford, Miss Mary Ann Sloan, Mr. Dennis Williams, Douglas Wilson, and Miss Teresa Hoyt. Again, the ruling from the Federal Court of Appeals clearly holds for the plaintiff, for myself, the state trial court judgment. There was no error in entering the state trial court judgment. It was affirmed. The defendants cannot have relief of the state trial court judgment according to the signal they used, and it holds a lifetime conviction. It's for a very serious situation in which the monetary judgment, the state trial court judgment, was affirmed. The Uniform Commercial Code, the UCC, which is listed in the back of these textbooks. They have a section on secured transactions and default judgments. The secured transactions and the default judgment are thoroughly covered according to the Uniform Commercial Code, and the section on default refers to the money judgment as collateral, chattel paper, and any instrument that shows an obligation of money and allows the right to redeem the collateral at any time. The UCC code has a section again on secured transactions also, and declares the money judgment as a secured transaction according to the section and the subparts. Since I've been asking for payment, I have been getting conflicting information from what is on the ruling and order. The letters that SSA General Counsel have mailed to me are in conflict from what the Judicial Review and has produced, and it is a major reason I feel uncomfortable in telephoning and verbally discussing payment because of the overtone in the letters that basically SSA is not going to comply with the court review. The attitude has been very hurtful, and I find it wrong, and I'm not willing to meet with such a strong opposition as what is in the correspondences which has been coming from the Office of General Counsel, including the United States Attorney's Office. The office is listed on the instructions to service the civil action complaint. And furthermore, if the need for redress was not needed, then the Federal Appeals Court and the Mississippi Supreme Court would not have ruled and given an order citing the cases they cited and with the signal C in quote. Also, the remand of federal court by SSA would not have stated civil action if they did not want to provide redress, and if needed, and again as declared by the courts. So there's no need to take frustration out on me. The serious misclassification of the Social Security disability on the first ALJ's decision, which asked to be corrected on the second ALJ's decision, could be used to discredit me and as ammunition against me in avenues of different business or personal arenas. It has been used to discredit me, and it has been used as ammunition against me, and I find it very offensive and very wrong. I'm going to elaborate just a little bit more on that in a minute, but there are other reasons I must continue to seek a payment, and I have creditors who need their money. I have never received the money that was allotted or awarded for back pay and money damages. I have never received the correct amount of Social Security disability benefit money based on the right condition. The tender level is half. I am living off half of what should be being paid. I am referring to the past, where the plan to achieve self-support has never been implemented. The missing, as it says in the CFRs, it was money for education. You can receive full SSI payment. That would for 48 months or longer, and that would bring it up to 20, I don't know, between 20 and 25,000 and 35,000, which shorted me, and the wrongful, the misclassification, in time the court review and everything. Again, the basic necessities are 200, 250,000, and just minimum, minuscule cost, gas, housing, food, clothing, basic necessities. When both the appeals court ordered and ruled and cited what they ruled and cited upon, I knew I could declare retirement, and I could retire off the money judgment, which includes back pay and damages. And I cannot, I can't let you have it. I can't let you have my retirement that was mine, and it was money to get my shoulder fixed, to get my arm fixed, to take a lot of pressure off the upper chest, which I complained to my cardiologist about. I've told my heart doctor about this situation thoroughly. I've told other medical upper arm specialists, shoulder doctors. The shoulder needs attention. The palsy doctor in which I need to go see is in Los Angeles. He's Dr. Mike Pearl. I don't have the funds to get out there to get my arm fixed. It drops severely, very badly, when I have to discuss the situation with appropriate people in high-ranking positions, and it makes me very nervous, and it's hurting, and it hurts bad. Now I'm trying to get here and get to the closing. I was very pleased with the combination of paralegal work and the paralegal degree. They worked well together. I'm happy. I can put a master's degree with the diploma from the University of Memphis. Again, I wasn't interested in being a paralegal. This was me before I applied for my disability. I had a modeling portfolio in New York put together in 1992 and 1993, and